Okay, well, welcome everybody and thank you for joining us. This is the first of two Moncton webinars on last week's Digital Markets Bill. Now, as you may know, the bill is 388 pages long, and the Moncton team has worked tirelessly on it over the bank holiday weekend. And that means that cockapoos were left unwalked, Waitrose was unshopped, sourdough bread was not baked, and children were left to play in the traffic. But as a result, we are here ready to tell you all about the bill. Next week's seminar at the same time is going to be on consumer protection, but today's is about the competition law provisions of the bill. And that is part one, digital markets, and part two, about competition law more generally. Now, as you probably already know, the bill proposes some important and far-reaching changes, including significant new ex-ante powers for the CMA in respect of so-called big tech, but also other important changes for competition law more generally. And we will be talking about designation of strategic market status, pro-competitive interventions, a new and exciting thing, mergers, enforcement, and changes to the Competition Act. We have three fantastic speakers, as you can see, Robert Palmer-Casey, Alison Berridge, and Daisy Mackesy. They're all highly experienced competition lawyers. We're going to structure this as a discussion. If you have any comments or questions, please send them in the Q&A box. The chat, I'm told, is disabled, and we will deal with them if we can. So I'm going to start with Daisy, who's going to tell us what part one of the bill is all about.
Thanks, Tim. I'm hoping there are no social workers who are interested in competition law right now. So part one of the bill, in a nutshell, is the fairly long-awaited legislation that gives the Digital Markets Unit, which sits within the CMA, new statutory powers to regulate digital markets. And the government describes them as powers to promote competition in digital markets for the benefit of consumers. And as we all expected, it's going to work by targeting, really focusing in on the very biggest companies in the sector. And the idea is that the DMU will designate those companies as having strategic market status. And then the bill will have three consequences for them, or three main consequences for them. The first is the conduct requirements, and I'm sure we'll come on to talk about them in a bit more detail. But broadly, the DMU will be able to set rules about what these companies must and must not do. The second is that the DMU will have the power to require the companies to remedy competition problems. So that's the pro-competitive interventions bit. And the third kind of main consequence is that there will be new reporting rules in relation to mergers involving those companies. So yeah, that's part one in a nutshell.
Great, and we'll talk about all those things in a bit more detail in a minute. But Robert, why do we need these powers at all? Why aren't the CMA's existing powers sufficient here, particularly, obviously, Chapter 2?
Well, if you were reading the government's press release accompanying the announcement of this bill, you might well ask that question, since that says that the new regime includes powers to tackle what it calls the excessive dominance of a small number of tech companies. And it says that that dominance has stifled innovation and growth, held back startups and smaller firms. And if it really were as simple as that, you might wonder why Chapter 2 powers and market investigation powers weren't enough. But of course, the reality is far more complex than that press release might suggest. And that, as we all know, digital markets have been on the CMA's radar for quite some time. It goes back to the Digital Competition Expert Panel, which many will remember was chaired by Professor Furman, and that first recommended the establishment of a digital markets unit back in March 2019, and that led on to the CMA's market study into online platforms and digital advertising that reported in July 2020, and it was only after that the government then committed in November 2020 to establish and resource a new digital markets unit within the CMA, which was set up from April 2021. But this bill puts that on a statutory footing and grants it new powers. And of course, it was the report of the Digital Markets Task Force, which was set up to provide advice on the design and implementation of a competition regime for digital markets, which recommended that the Digital Markets Unit should have powers to designate an undertaking with strategic market status. And since then that we've seen CMA investigations and market studies into mobile ecosystems, for example, which has already recommended a market investigation into mobile browsers and cloud gaming using existing powers, but also set out a number of other recommendations which really were anticipating this bill in due course, and particularly made recommendations as to pro-competition interventions and various conduct requirements to be placed on firms. And that, of course, is only possible with this bill. Other Competition Act investigations in this sphere, of course, progress. We've had Google Sandbox, AdTech, in-app billing, Apple App Store, and so forth. But that's all ex post. And what this does is really expand the ambit of ex ante powers beyond what can be done at the moment. It's, of course, parallel to, but not identical with, the EU Digital Markets Act. And it's right to note that there is some controversy about the need for this at all. There's been some academic criticism. The central criticisms are that the vagueness of SMS status reduces legal status and gives excessive discretion to the DMU. We might come on to some of that later on. And the proposed codes of conduct, the conduct rules, will allow the CMA to substitute its business models for those of SMS firms to a level of detail that includes governing their terms of business, mandatory data sharing, interoperability, and amounting, in effect, the criticism suggests, to central planning reminiscent of old-style regulation of utility industries, with consequent reduction in innovation, investment, and so forth. And there's also a concern that the DMU will instill a precautionary mentality to regulation that's at odds with the disruptive and innovative nature of digital platforms. But be that as it may, the bill is now before Parliament. It's had its first reading, and we will go through what powers it currently envisages and how they might be applied.
Yes, thank you. We're going to talk a little bit later about the differences here between this proposed legislation and the EU's Digital Markets Act. But for now, what we'll do is come back to the core concept, the gateway concept, which is SMS, and try to understand what the criteria are that need to be satisfied in order to be designated as having strategic market status. Daisy.
Yeah, I count 5 criteria that need to be satisfied. The first 2 are fairly broad and seem unlikely really to weed out many companies. And they are, firstly, that the company needs to be carrying out a digital activity. That's defined in clause 3, and it's broad. It's providing a service using the internet, or providing digital content, or any other activity for the purpose of doing one of those first 2 things. The second condition is that there has to be a link between the digital activity and the UK. So it's a sort of a jurisdictional threshold, a UK nexus. But again, the threshold seems fairly low. The link with the UK will be sufficient if the number of UK users carrying out the relevant digital activity is significant, or if the digital activity is likely to have an immediate, substantial, and foreseeable effect on trade in the UK. And just pausing there for a moment, since you mentioned the DMA, it's worth noting that that requirement for a significant number of users relates to the digital activity itself, not to the undertaking. And that is a difference with the DMA, which sets a number of users for an undertaking. So 2 criteria that seem likely to be relatively easily satisfied. There are then 3 criteria which have a bit more teeth, I suppose. The first is that the company has to have substantial and entrenched market power. That concept isn't defined any further in the bill, but the bill does say that it needs to be based on a forward-looking assessment over at least 5 years, taking into account developments that would be expected without an SMS designation. So it requires us to look at the counterfactual, assuming that the undertaking isn't designated. And again, the bill doesn't specify what kind of factors the DMU might take into account, perhaps that's something that will be covered in guidance in due course. But one assumes it will look at things like the potential growth of existing competitors, or emergence of new competitors, changes in the market landscape, for example, because of innovation. And at risk of stating the obvious, presumably it will also require the market to be defined. You can't assess the extent of market power without knowing what the market is. And of course, we all know that those sorts of market definition issues can be quite contentious. The second criteria that seems to have real teeth is that the company must have a position of strategic significance. That's dealt with in clause 6. There are 4 gateways to having strategic significance. I won't read them all out. The first one is that the undertaking has a position of significant size or scale in respect of the digital activity. And the reason I've chosen to tell you that one is because it really seems like it's probably going to catch many of the likely candidates, particularly given the need for substantial and entrenched market power too. Although, having said that, I did notice that this requirement here is drafted in terms of the digital activity. So you need a position of significant size or scale in respect of the digital activity, whereas the previous requirement, of course, relates to market power. So there is at least scope for an argument that entrenched market power doesn't translate into significant scale in respect of a digital activity. I think if you could say that the digital activity spanned more than one market, a theoretical example, but in one of those market investigations that Robert mentioned, the CMA identified a market relating to the supply of mobile browsers in the UK. And the CMA expressly said that that market didn't include desktop browsers. But when you come to working out what the digital activity is the digital activity the same as the market? Or might you say that the digital activity is the provision of browsers, in which case it could span more than one market? So there's potentially scope for issues to arise there. And the third criteria with teeth, and perhaps the most important one really, is the turnover condition. And in clause 7 at the moment, that's set as £25 billion of global turnover, or £1 billion of UK turnover, and that's not turnover limited to digital market activities. And that turnover requirement was introduced following consultation to provide greater certainty about what firms are within scope of potential designation. So it responds to one of those points that Robert flagged that had been an area of criticism. And I think it does do that. I think it does provide certainty because it's a really big ask. And as you might expect, you know, it's going to catch people like Amazon, Apple, Google, Microsoft, Meta, but it wouldn't currently catch companies like Spotify or TikTok. So of course there's scope for things to change, and the DMU can start a new investigation whenever it has reasonable grounds to consider that it might be able to designate a company. So that the DMU may well keep an eye on the growth of companies that seem to be approaching the turnover threshold. Equally, on the other hand, designation is for a period of 5 years, but it can be revoked before the end of the period. And so you can imagine a company might approach the DMU if revenue had dropped below the threshold. Just finally on designation, it's worth noting that the SMS decision notice, so the thing that has to be published at the end of the investigation to say that the DMU has decided to designate a company, has to describe the digital activity singular with respect to which the designation has effect. And one of the process points which I wondered about is whether the DMU would have to publish separate notices in respect of different digital activities carried out by the same undertaking. So we can imagine, for example, that one undertaking might be designated in relation to the provision of mobile operating systems and browsers and digital advertising. And it's not clear at the moment whether that's separate decisions or one decision. And one might think the former, because of course they're potentially separate markets, but that's something that might be covered perhaps in guidance in due course.
Daisy, thank you. It's striking that at least 2 of these criteria are highly evaluative, aren't they? The substantial and entrenched market power and position of strategic significance. And as you said, if it involves questions of market definition, it's already almost by definition contestable. We're going to hear later about remedies, but it does seem obvious that there could be challenge here for either whether somebody is designated or is not designated by people who might feel quite strongly about this, given the potential remedies and measures that it unlocks. But what I was wondering is, with the turnover threshold being set so high, 25 billion global or 1 billion UK turnover, is it in fact essentially just obvious who this must be about? I mean, you named quite a few of the famous names there by way of example. And I don't know whether really in the real world above that turnover threshold, there is not going to be much debate.
Yeah, I mean, that's why I think the turnover condition is so significant, because it really does seem to limit this to a pretty small group, at least at the moment. Yeah. And of course, things may change.
Yeah. Good, excellent. Well, let's turn now to something that, Robert, you already touched on, which is the way in which this differs from last year's EU Digital Markets Act, which has, I think it's fair to say, a slightly more rigid rubric for designation. So, Robert. You're on mute, Robert.
Sorry, I'm trying to save the audience from a barking dog earlier on. There are some differences and there are some important differences, and you've touched really just now on the turnover condition. I think this is actually going to lead to quite potentially wide disparity between the EU approach and the UK approach. Let's just recap some of the main differences. So the EU, in order to be designated as a gatekeeper, as they call it, requires 3 tests to be met for designation. The first test is whether the undertaking has a significant impact on the internal market. And that is analogous in some respects in the UK version to the link to the UK needing to be satisfied, but it's not identical. The second EU criterion is that the undertaking provides a core platform service, which is an important gateway for business users to reach end users. And of course, that's analogous in some respects to the position of strategic significance, which must be demonstrated in the UK version. And the third criterion for the Digital Markets Act is that the undertaking enjoys an entrenched and durable position in its operations, or it's foreseeable that it will enjoy such a position in the near future. And that has some parallel but difference to our criterion of substantial and entrenched market power in respect of a digital activity. And that last UK formulation, as Daisy touched on, is essentially undefined. Substantial and entrenched market power, well, what is that? If you look to the explanatory notes, all you'll get told is it means not small and not transitory. But still the import of the notion of market power, as opposed to in the EU, an entrenched and durable position. And we know that this substantial entrenched market power is presumably not and cannot be equivalent to significant market power in the SMP regulation sense. It must mean something else. But I wonder if there's nonetheless some vulnerability in the bill in this use of the expression market power. And actually, I wonder whether that might change over time as the bill goes through Parliament. But for the moment, unlike in the EU, a need to look at the extent of market power, whereas in the EU, you look at an entrenched and durable position. Now, in the EU, there are 2 ways of getting designated in which those 3 criteria can be fulfilled. The first, if you like, is the fast track, where those tests will be presumptively met if certain thresholds are met. And that means annual turnover of 7.5 billion euros in the EU in each of the last 3 financial years, or average market capitalization of 75 billion euros, and at least 45 million monthly active end users and 10,000 yearly active business users who are established in the Union in each of the last 3 financial years. If you tick all those boxes, then you are presumptively designated. It's a strong presumption. It's only going to be displaced if you, the undertaking, can demonstrate exceptional circumstances such that you don't meet the core requirements I outlined at the beginning. But it's also worth remembering there's a second route to designation, which doesn't depend on any of those thresholds, on any turnover threshold or number of active users, which is a more nuanced assessment following an investigation based on size, operations, position, number of business users and end users, but also matters like network effects, data-driven advantages, scale and scope effects, business user or end user lock-in, and corporate structure. So none of those fixed by reference to minimum levels of turnover, so not the same cutoff which is applied in the UK. Also worth noting, there's a difference in process. For the fast track route under the EU, companies have to, who meet those presumptive criteria, have to in effect self-report that within 2 months, and the Commission will then designate them within a further 2 months, unless there's an argument about exceptional circumstances. On the slower track, it will open an investigation, a market investigation, and it will, under the Act, endeavour to conclude its investigation within 12 months, including endeavouring to communicate its preliminary findings within 6 months. As in the UK, the CMA will get 9 months to decide whether or not to designate a business as having SMS following an investigation and a public consultation. And if it doesn't reach a positive decision within that time to designate, then that is taken to be a decision not to designate. So some parallels to the merger regime there. And the other key difference between our regime and the EU regime is that if you are designated, and we'll come on to look at the consequences now, but the EU has very prescriptive rules, obligations, prohibitions set out in Articles 5, 6, 7 of the DMA, whereas our bill, the UK bill, provides for business-specific conduct requirements, business-specific obligations to be imposed, again, following a separate process, an investigation which follows on from designation. So it's a more tailor-made regime, albeit in practice, many of the obligations which may be imposed following that may well have a lot in common with the sorts of things which can be imposed or which are automatically imposed in the EU. But there is that very different approach.
Thank you. So in a nutshell, 2 different regimes, broadly similar objectives, some of the same structural qualities, but actually quite different in the detail. Is that a good thing? Well, that's for others to decide. But let's move on anyway now and talk more about the detail of the consequences of designation, focusing, of course, entirely on the new UK bill. Daisy, can you talk us through that?
Sure. So let's start with the conduct requirements, which are really the big new ex ante part of this regime. So the DMU can impose conduct requirements on undertakings once they're designated as having SMS. And the bill defines a conduct requirement as a requirement as to how the designated undertaking must conduct itself in relation to a relevant digital activity. So if you stop there, it could cover pretty much anything, it seems. There are 2 potential breaks in the bill at the moment, although a little bit like the brakes on my bike, I'm not sure they're going to be very effective. The first is that a conduct requirement must be for the purpose of meeting one of 3 statutory objectives. Those objectives are fair dealing, so users or potential users being treated fairly and being able to interact with the undertaking on reasonable terms. The second is open choices, which means that users must be able to choose freely between the services or content provided by the designated undertaking on the one hand, and those provided by other undertakings on the other. And then the wonderfully named trust and transparency, which means that users must have the information they require to enable them to understand the services and the terms on which they're provided and make properly informed decisions. So I think it's probably fairly clear that those objectives are themselves pretty wide, perhaps especially the first one, fair dealing, which seems really to cover all of the dealings between a company and its users potentially. The second potential break is that a conduct requirement must be of a certain type. Again, the lists of the certain types of conduct are drawn quite widely. I won't read them all out. It's clause 20 if anybody really wants to have a look. But to give you a flavour, the DMU would have the power to impose requirements that oblige a designated undertaking to trade on fair and reasonable terms. So back to fair and reasonable. Oblige them to provide information or explanations to users, prevent them from restricting interoperability or generally restricting users' ability to use the products of other undertakings, and also prevent them from using data unfairly. So again, you can see that these are widely drawn and in and of themselves contain scope for different interpretations. And I suppose, I mean, a few obvious points follow from that. The first is that the DMU itself might have quite a job deciding what requirements it should and shouldn't impose. And then the scope after that for argument about whether they've done the right thing or whether they've missed any is potentially quite broad. It's also possible that these requirements are going to impose quite a big compliance burden on the designated undertakings. And on that, I think it's worth noting that this isn't a one-shot game. You know, it's not as though the DMU sets the conduct requirements initially and then revisits them in 5 years. The bill proposes an ongoing duty on the DMU to keep the conduct requirements under review, including not only whether to vary or revoke them, but also whether to add new ones. So in theory, at least, the DMU could add requirements on almost a rolling basis, albeit always following consultation. And that possibility of sort of ever-shifting sands could also be a concern for designated undertakings, and provide scope, of course, for other businesses to seek to get new requirements added. And as Robert has said, I think for me that's probably the biggest contrast with the EU regime, because those obligations on gatekeepers under the EU regime are set by Articles 5, 6 and 7, and of course they apply to all gatekeepers in the same way. Whereas this regime envisages the possibility that different designated undertakings could be subject to different codes of conduct, rules of conduct. And I think even if they've been designated in respect of the same digital activity in theory, which potentially provides scope for distortions. So no doubt something that people will be keeping a careful eye on.
Yes, including the CMA, inevitably. Absolutely. But it is striking, again, as you said, what you call the first break, the 3 objectives that are in the bill themselves are both very wide, but also highly evaluative again, aren't they? Because it talks about fair dealing, which is interaction on reasonable terms. And then I think it's right to tell me if this is the case, that the list of potential requirements are exhaustive. They're not just examples, are they?
They are exhaustive. Yeah. Right.
So that sounds like quite a potentially an element of legal certainty compared to statutory lists, which often are just by way of example. But then when one looks at them again, there is powerfully evaluative language in there. So obliged to trade on fair and reasonable terms, which really just restates the fair dealing requirement. And then another example, prevent them from using data unfairly. And it's hard to think of a less precise term in the law than unfairly. So again, as you were saying, the scope there for different requirements to be imposed on different designated undertakings and the sheer lack of certainty about what they might contain does seem like an area of, at least, shall we say, sensitivity.
Yeah, absolutely.
Okay, great. Thank you very much for that. And now there is another novelty here in this section of the bill in terms of pro-competitive interventions. Robert, can you tell us a bit about that?
They are, as you say, a novelty. Pro-competitive or pro-competition interventions, in fact, are abbreviated to PCIs in the bill, and an intervention must follow what's referred to as a PCI investigation. And that investigation will look into 2 things: whether a factor or combination of factors relating to a digital activity is having an adverse effect on competition, and B, whether making a PCI would be likely to contribute or otherwise be of use for the purpose of remedying, mitigating, or preventing the adverse effect on competition. So some similar language to that we are used to under the market investigation regime, but some differences there, in particular, whether a PCI would be of use for the purpose of. And the CMA, in deciding whether to take such action, must balance any adverse effect in the market which is identified against any benefits to consumers. And then the intervention, if one is justified, may take one of two forms or both. It may take the form of a pro-competition order, which imposes requirements on the undertaking as to how it must conduct itself. Or the CMA can make a recommendation to any person exercising public functions as to the steps which the CMA considers it ought to take. But in terms of those orders, note that, again, there's overlap between what a pro-competition order can do and what can be done following a market investigation reference. Indeed, pro-competition orders can include the same provisions that can be included in enforcement orders under Section 161 of the Enterprise Act. Final orders, in other words, following market investigation references. But the bill envisages that the process of making a pro-competition order can be made whenever it identifies a competition problem and believes that the competition order would be useful to remedy or mitigate that problem. And there's a streamlined process compared to the market investigation reference procedure that's still including a public consultation. And another innovation, the use of including trial basis requirements to see if any measures would in fact be effective. Noting also that the reasonable and practicable language which appears in the Enterprise Act, that the action taken by the CMA should take such action as is reasonable and practicable to remedy, mitigate, or prevent the AEC under the Enterprise Act, that language doesn't appear in the bill. Query whether that's going to make any real difference given general requirements of proportionality, but another notable difference for what it's worth between the new regime and the existing market investigation regime. So what are the difference between conduct requirements and pro-competition interventions? Similarities, obviously, are both require designation as an undertaking having SMS first, and both can only be made following consultation, but notable differences apart from that. First of all, on process, the CMA has 9 months following a decision to launch a PCI investigation to make its decision, but there's no time limit for conduct requirements. Conduct requirements are ex ante. PCIs are perhaps similar to existing ex post powers. They require the CMA to identify a competition problem and then seek to remedy that. And for the same reason, the conduct requirements have to be judged against a pro-competition objective, such as fair dealing or open choices, as Daisy went through, whereas the PCI depends on the identification of an adverse effect on competition. There are also differences on the enforcement process in respect of each. We'll come to that, I think, a bit later on, Tim.
Thank you very much. And while you were speaking, comments are rolling in and questions for which many thanks. But one that's really on point here that is really, if I may say, a good comment, wherever the question leads us, which is really about the overlap between this set of powers and the current market investigation regime. And it really takes us back to where you began, Robert, which is, well, what is it that's needed here that is over and above the existing regime? And the suggestion in the comments is that, if I just read it out, that the new law focuses more on simplifying the process and lowering the legal test for digital markets rather than new remedy powers. And so I suppose there's a suggestion even that perhaps it reduces legal uncertainty in that respect.
Well, arguably, certainly, I think the biggest impact is going to be the streamlining of the process. But I think there's also, and there's room for argument here as to how the difference of wording is really going to have an impact. But that just strikes me as being a bit broader and more flexible, both in terms of the circumstances in which PCI interventions can be imposed and the link that they must have to the remedy, not just, as I said, in the reasonable and practicable, and not just for remedying or mitigating or preventing adverse effect, but being of use for the purpose of, which suggests a potentially more indirect relationship. But how that's going to cash out in practical terms, we're going to have to wait and see.
Yes, good, thank you. Well, let's move on to another topic, which is rules on mergers, still within the context of undertakings that have been designated with SMS. And for this, I'm going to turn to our in-house superstar resident merger expert, Alison, who I think with a bit of careful product placement may even have a copy of her excellent book on the shelf behind her. But whether it's there or not, I recommend it. Alison, tell us about the new rules on mergers for undertakings with SMS.
Yes, so sticking with our structure, what we're talking about here is the mandatory reporting requirement for these designated undertakings. There is a broadening of the general jurisdiction for mergers, which will also apply to those undertakings, but we're going to cover that later. So this is part of the response to the concern sort of aired a few years ago about big tech companies scooping up small businesses before they really get a chance to become competitors, let alone big competitors, and that overall added up together that sort of habit is stifling competition in this sector. And obviously this particular reform aims at the part of that concern, which is that the CMA can't always even see or pick up in its kind of horizon scanning activity these particular transactions. So it's mandatory reporting. It's triggered on some relatively bright line thresholds. So there's a reasonable amount of certainty as to whether a particular transaction is caught. So the consideration must be over 25 million. The shares or voting rights must cross one of three thresholds, and they're 15%, 25%, and 50%. So that's a little bit easier to apply than material influence, which we know is a bit more nuanced. And the target must carry on activities or supply goods or services in the UK. The CMA will provide us with a new form for using, so you don't have to use the merger notice, though I don't think we've seen that yet. Once that form is sufficiently filled in to the CMA's satisfaction, there's a waiting period of 5 working days before closing can take place. And really, perhaps the question here is, I think most of the businesses who are going to be designated undertakings under this sort of part of the Act are probably already taking a pretty cautious approach in their acquisitions, especially given the discussion about this sort of scooping up problem. So what sort of actual impact this will have? I mean, in some ways, it may be positive for some of them because it's a new way of bringing your merger to the CMA's attention and getting a view, which is in some ways easier than a briefing paper or a merger notice. I thought it was interesting, the impact assessment does make the fair point that because this is aimed at finding transactions that were not previously found, it's very hard to say how many it will find, because until you create this obligation, you don't know. But it's interesting that the impact assessment assumes 35 reports per year with a 10% conversion into investigations. So I think that implies something like 3 new investigations per year as a result of this reform. But clearly we will see if and to the extent this makes it into the Act. I'll pass back now, I think, to Daisy next.
Before you do, Alison,
Okay.
I'm just going to exploit a bit of chair's privilege here and ask you about a question that's come in, which is a sort of merger-related question. And the point has been made that there's quite a lot here about behavioural undertakings and commitments in this Act, and we've heard about some of that already. We're going to hear more in a minute. But as a merger lawyer, obviously, this is a very familiar territory. And the point is made that the CMA is not generally very keen on behavioural type undertakings. I mean, here, obviously, we've got a kind of mechanism of ongoing supervision that's sort of built into this regime. But the question is really, are the courts well equipped to consider such points? In other words, the efficacy or appropriateness of such remedies. And I admit I would start from a position of skepticism about that question because of the potential for deference to the judgment of the CMA on something like that, which is of course heavily economic, see the Scott case and so forth, but you probably have a lot more feel for this than I do.
Yeah, so I think it's kind of, everyone knows that in the mergers world, the CMA really doesn't like behavioural remedies.
Yeah.
They say you're changing the structure of the market. The cleanest way of resolving that is to change it back or deal with it in a structural way. So for people who are thinking in a mergers way, this sort of focus on behavioural undertakings, sort of in the way that Daisy and Robert have been talking about, would seem odd. But then I think possibly because the harm that those are aiming at isn't a sort of structural change to the market, they're aimed at sort of things that are growing up organically, they probably fit a bit better. And then you're asked specifically about the courts being good at sort of assessing those, which I might hand over to Robert, if that's all right, and not an absolute pass.
Well, perhaps we'll pick that up again, because Robert's going to talk in a minute about what the appeal thresholds are in the legislation, so we can perhaps think about it again. But that's really very helpful. Thank you. Well, let's go to Daisy now to talk about timing. When is any of this going to happen if Parliament gives it its blessing?
Well, I can probably be fairly brief, because the short answer is we don't know. Of course, the bill needs to get through Parliament. That's going itself to depend on the government's own priorities and the extent to which it gets a smooth passage, or whether perhaps some of the things we've been talking about or other things are given more scrutiny. So very best guess, it could be passed late this year, maybe early next year, coming into force a few months later. But then, of course, as we've heard, it will be necessary for the DMU actually to designate the undertakings as having SMS. As Robert mentioned, I think that process has a 9-month time limit. I actually saw a question about extensions. The answer is it can be extended for 3 months if the CMA considers that there are special reasons for doing so. Not quite sure what those special reasons might be, but it can be extended. But assuming the DMU takes around 9 months, we might get designated undertakings perhaps at a push late next year, but probably 2025. At that stage, the provisions relating to PCIs and mergers apply. But on the conduct requirements, then there's another stage, potentially quite a lengthy stage, because the DMU is going to have to set out its proposals and consult on them and so on before you get a final decision. So in terms of conduct requirements, I mean, definitely not before 2025.
Right, so some way to go. Well, if it does become law, what about the enforcement regime? Tell us about that.
Sure. I mean, the first thing to say is that the bill confers on the DMU the kinds of investigatory powers that you would expect. So information gathering, powers of access, powers of entry, interviews, and so on. In relation to conduct requirements, the enforcement process is slightly more lengthy. So you have a conduct investigation if the DMU has reasonable grounds to suspect that a conduct requirement has been breached. And of course, going back to the question Alison was dealing with, that does require sort of ongoing enforcement of behavioural measures. Perhaps most interestingly, that investigation has to include consideration of countervailing benefits. So whether the conduct at issue gives rise to benefits to users which outweigh the likely detrimental effect on competition arising from the breach. That's quite an interesting point, because to have had the conduct requirement imposed in the first place, you would have thought that that would have been part of the consideration.
And it's a less precise test than a kind of Article 1013 type analysis.
Yeah, absolutely. Although I think it does require that the undertaking to show that the benefits couldn't have been achieved through other means. Okay. So you've still got that necessity test. If the DMU finds that a conduct requirement has been breached, then you get an enforcement order or perhaps commitments. And it's only when the enforcement order is breached that the DMU can impose penalties in the way of fines. And the fixed penalty is up to 10% of the total turnover of the undertaking, so potentially very hefty fines. But as I say, you'd have to have the enforcement order and the breach of the enforcement order before you get there. The same fining powers apply to breaches of pro-competition orders. So, I mean, broadly speaking, I think the point is that if you breach an order, whether that's an enforcement order or a pro-competition order, you could end up with this fine, but the conduct requirements aren't in themselves orders. There's a further step in that process.
Great, thank you very much. Well, let's turn now to what happens if there is a challenge to any of these measures. Robert.
So the challenges to all decisions under Part 1, save in relation to mergers and some merger-related penalties, is governed by Clause 101 of the bill, and that provides that anybody with sufficient interest may apply to the tribunal for a review of the decision in accordance with the tribunal's rules, and the tribunal must apply judicial review principles. And aside from dismissing the claim, all it can do is quash the decision in whole or part and remit that decision back to the CMA. And as I said, that applies to penalty decisions as well, except to penalties imposed under two provisions, both of which relate to specific merger situations. Section 83(4) is where a designated undertaking has, without reasonable excuse, failed to comply with a requirement in Chapter 5, which is what deals with mergers. And the second is Section 85, where the penalties for failure to comply with investigative requirements in respect to the CMA's merger functions. So those two are still governed by the existing regime under Section 114 of the Enterprise Act, which gives a more merits-based appeal with power for the tribunal to vary the amount of the penalty or quash it altogether without remitting it back to the CMA. And challenges to decisions relating to mergers are still governed by Section 120 of the Enterprise Act. As we know, that's a judicial review test in any event. So if we go back to the question that was raised earlier, if a decision under challenge relates to a behavioural requirement, there is the scope for appeal, but it will be a judicial review test. And so in answer to the question is how well is the court equipped to consider such points? I think my honest answer to that is not terribly well, because they will defer, as Tim mentioned, to the judgment of the CMA in a large number of cases. And I think it would only be something which you can show is irrational or wholly disproportionate that you're going to have much chance in principle of establishing a merits argument against that. Obviously, fair procedure, relevant considerations, those sorts of JR arguments still open to you on the facts of any one individual case. But in terms of rationality and proportionality in particular, we can expect the courts to, the tribunal, to pay a fair amount of deference to the CMA, I would have thought.
Yes, well, if I may, I agree with you very much about that. And if you take a sort of 20-odd year view of judicial review, there was a period in the 2000s, possibly post-Human Rights Act, where the judicial review courts were becoming quite interventionist. And then I think the pendulum has very much swung the other way. And deference to expert regulators is very much the framework through which the court will view any challenge of this kind. And when these decisions are economic and evaluative of the kind that clearly is hardwired into this bill, I think that is going to be quite hard to show a judicial review threshold has been crossed. Well, thank you for that. Let's now turn to part two, conscious of the time. But Alison, part two, competition. It deals with rather a lot of different things. Can you give us a sense of what is in it?
Yes, so part two is very different really from part one. Part one is a bit like the CMA getting a new car, and part two is a bit like the CMA getting an MOT in its old car, because it's a series of almost miscellaneous changes to existing tools, existing statutory tools. If there is a theme, is that almost all of the changes are sort of expansive to the CMA's powers, or sort of allow more things to happen. I think some are designed to simplify things as well, and make things work better. So conscious of time, I'll just try and take it at a bit of a pace and just pick out a couple of things to focus on. So one aspect that's sort of, I think, attracting a lot of attention is that there is a new jurisdictional threshold for the review of mergers. So we've long been used to having a turnover test and a share of supply test, and their alternative routes for the CMA to have the power to investigate and intervene in a merger. The turnover test going up with inflation, that's kind of expected and normal. The third alternative test is called the acquirer focus test, because it's very much focused on usually the acquirer, but one party to the merger. And it's really about big businesses which are big in the UK and have a big market share and are making acquisitions. So aimed a little bit, I think, at the scooping up problem that I was talking about earlier. And so specifically, that test is met where one of the enterprises has a UK turnover exceeding 350 million and a share of supply in the UK, or a substantial part of the UK, of more than 33%. And then the target, or the other party, carries on at least part of its activities in the UK or supplies goods or services in the UK. So it's a very logical extension, because the share of supply test is obviously aimed at mergers which are horizontal, where there's a horizontal overlap. And we've long known that that's not the only way a merger can create harms. There are vertical mergers, conglomerate mergers, or mergers which impact potential competition. And so we do need a jurisdictional test that is a bit more aligned to that. So that all seems quite logical and to make sense. The real question is probably whether it makes much difference in practice, because the share of supply test was so elastic that it almost allowed the CMA to look at any merger that was of interest to it substantively. And I have on occasion said to clients, look, please don't get caught up with this share of supply stuff, because they'll do what they want and there isn't that much judicial oversight. But I did look again at the impact assessment, and that's had, I think, advice from the Mergers Intelligence Committee, who obviously are the experts on where the CMA sees these sort of boundaries. And they believe that the new test will generate between 2 and 5 additional phase 1 reviews per year. So not a massive change, but clearly there were things that the MIC was looking at and saying, we don't think we can get to that. And now they'll be able to. So we look forward to sort of watching those come through. I think possibly it might also be quite useful in interpreting the old test. So I think if you're in a situation where the CMA is looking at something through a sort of vertical lens and says, oh, we don't actually quite meet the 33% or the 350 million, or one of them, but we'd like to do what we've always done before and try and use the share of supply test. I think the existence of this third test might make that a bit harder, or suggest to the courts that the intention of Parliament was that the share of supply test should go back to being for horizontal overlaps. So there's a sort of difference there. There's also a new safe harbour for small businesses, so where each of the parties to the merger generates less than 10 million of turnover in the UK, the CMA won't be able to look at that. And that's designed to keep small businesses sort of safe from what is quite an onerous sort of jurisdiction, which I think is intended to operate in parallel with the existing de minimis regime. So we've got quite a lot of limbs now to our jurisdictional assessment, though they all make sense individually. It's quite complex now, I would say, to explain.
And there is there essentially a new jurisdiction, isn't there, for the CMA in this? And someone has commented in the Q&A that there are really quite a lot of new tasks for the CMA here, but according to this person who's posted as anonymous attendee, the DMU will have around 200 staff members working on the DMCCB, compared to around 70 on the DMA with the Commission. So I don't know if this is right, but if it is right, it sounds like the CMA is going to get the firepower to make use of these powers.
Yes, I mean, 100%. I think that might be, it's always difficult to know who's supposed to be doing what, and whether those are apples and apples, and whether other people in the Commission will be doing that stuff. And it's not sort of my expertise. Obviously, I think Daisy or Robert might have some views, because I think the DMU is really focusing on that part one.
But from a merger point of view, there is this new acquirer focused test does potentially bring quite a lot of things within the purview of the CMA, doesn't it? In terms of, for example, someone suggested acquisitions by hedge fund might do.
Yes. I think it's important to remember that it's a jurisdictional threshold, so it creates an option for the CMA, but it doesn't mean that they would necessarily be interested. So you could see in theory that anyone who's sort of got a strong market position in one area. So, you could be the biggest supplier of biscuits and you could buy a shoe business. And in theory, this new test brings you into scope. But of course, it doesn't mean that the CMA is going to do anything about it unless there's a connection between biscuits and shoes that we haven't previously noticed.
Okay, well, thank you. It is now 2 minutes to 2. So can you have a quick go at the changes to the Competition Act in 90 seconds?
The most interesting feature for me is extraterritoriality. The Chapter 1 prohibition now has another. Previously, your agreement had to be implemented in the UK, or it's intended to be. Now there's a qualified effects test on trade in the UK. So that's quite a philosophical change, really. I tried to spend some time thinking about actual examples, which is quite tricky. But I did wonder, what about a cartel that was implemented abroad? So imagine banana producers who are selling sort of on site. So the cartel is actually implemented in Central America somewhere, but we're all paying more for our bananas. Is that a sort of case that's now in that wasn't previously in? Which is a question, not an answer. But it's offered as an example. And then to go with that, the Section 26 notices, they now get extraterritorial application, reversing the recent BMW judgment.
Well, the qualified effects test, it's a sort of irony that what's been imported here is a particularly problematic bit of EU law. And although it's been in the case law for a long time, I'm not sure how much it's really even been relied on by the Commission, as opposed to something that looks more like straightforward implementation. Uncertain, really, isn't it, what impact that will have? But tinkering with the wording of the Chapter 1 prohibition does seem like, by competition law standards, an exciting development. We are now out of time, and thank you to everyone who's posted questions, and I'm sorry that I haven't been able to pick them up. Some of them were fearsomely technical, and I thought it was a bit unfair to actually ask. But thank you very much. Thank you for everyone who has joined us this afternoon. Please do come back same time next week for consumers, and thank you very much to all of our panel for really fantastic contributions. Have a good afternoon.